Crime Network. I'm Michael Bryant. We're waiting for the court to return from their lunch recess in the rapper Young Thug racketeering trial. Based on my $40 Timex, should be about 15 minutes from now. The artist, whose legal name is Jeffery Williams, charged with violating Georgia's RICO laws and participating in criminal street gang activities. Testimony has been revolving around the fatal shooting of Donovan Thomas Jr. This is day 87 of trial. Kenneth Copeland, a.k.a. Lil Woody, is on the stand. He's going to give some background. Now, Woody was arrested in 2021 after a traffic stop uncovering a weapon. He had the weapon. He was already convicted of a felony during this 3-hour interrogation. Remember, he talked to the cops for 3 hours, and he expressed his willingness to help get a supposed confession from Young Thug. But earlier today, while the jury was not present, Copeland agreed to testify in court to talk about the Fifth Amendment. He may plead. Prosecution says that the witness agreement will give him use immunity, and that, just to make things a little more muddy, means can't use what he says on the stand against him. But if there is corroborating evidence of something else he says extraneous to his direct testimony, that can be used against him. Very hard for witnesses to understand that. So who knows? He might also be held in contempt for withholding any testimony. It's still yet to be figured out. So let's get you back into the courtroom. Listen to more of this morning's arguments outside the presence of the jury.
This morning, I'll make a part of the record the court's order giving him use immunity. Okay?
Good morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Gary. I would believe that.
What does that have to do? Let's cut to the chase. Okay?
So
all of that, it may be maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right. So I'll let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Gary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, we have not spoken to Mr. Copeland previously when he had open pending cases. We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or if Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that he hadn't spoke to him or that he wasn't his attorney. At that point, we continued to engage in conversation. Mr. Copeland engaged with us. On Monday, we reached out to Mr. Copeland to see if he wanted to come down to do witness prep. We did not meet on Monday. On Tuesday, we thought that he was going to get called. He came down here. We spoke. He asked us questions. We answered his questions, and we've moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case. Yesterday at our final prep session, we spoke with him. It was about 1 o'clock in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Max Shard in the hallway. As we left, we had our greetings. And then it was not until 6 o'clock last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the Fifth. In the state's conversations with Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to testify in the trial. Once we received the email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. 24-5-507, Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Miller.
Thank you.
So, Mr. Mallet, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Coming up, Mr. Copeland.
All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony, okay?
All right.
All right.
Your Honor, may I make the request of the sound report?
What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir. Go ahead and stand outside, please, if you wouldn't mind. We'll call you in just a minute. All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Well, Your Honor, good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it. But if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983. Also Waldrop, which is Waldrip, versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2, A, capital A, 620 Southeast 2D2. Oh, that's wrong, 829, 2005. And Your Honor, what I'd like you to do is, the state has stated today, and Ms. Hilton told me this last evening, I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 in the morning, Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is not subject, is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin, and then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They had investigators. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside of that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's do
Lawyer just said that, yes, I want to testify. So they asked him to step out again. I think at this point, his lawyer is talking to him again to clarify, why did you say you wanted to testify when you've been telling me that you did not want to testify? So there's a lot of clarification that needs to happen with this witness to ensure that he understands what kind of immunity he has.
Yeah, and Bob, to throw this into the mix, he has this conversation with cops, Mr. Copeland, I think it was 2019, 3 hours they chat. This is a leaked interrogation conversation, not part of this trial at this point. Maybe it never will be. But during that conversation, it's pretty clear that Mr. Copeland is trying to wheel and deal. If I could help you with this case, maybe you can help me with these pending matters. But now we've learned through this hearing, those pending matters are no longer pending. So what would Lil Woody think he can help himself with by testifying?
I don't know. I honestly don't know. And those conversations with law enforcement were going on, and the prosecution with respect to the use immunity deal was going on behind his lawyer's back, which to me is a big issue. Once somebody's represented, no one should be talking to my client from the government with respect to making any kind of deals. You go through the lawyer. To me, that's unbelievable. So I don't know what he can gain from it. I think he was convicted of a federal charge, I believe, felon in possession of a firearm. That's already done. That case is done. So unless it's an issue where he's got potentially pending cases, and they said, look, we've got this, and this on you. We just haven't charged him yet. If you work with us, we can help you out with those things. Maybe you fall off the ledger on those cases. It's the only thing that I can think, because typically in these types of situations, where you have a witness turn state's evidence, it's in a situation where you get picked up on a crime and they say, look, you can help yourself right here, but you're going to have to help us. We need something of equal or better strength in terms of a charge against a bigger fish. And which apparently is what went on here. I mean, obviously the target is Young Thug himself, and he gave information not of only of past crimes, but of future crimes as well that they were planning. So, what he's gaining out of it, we will probably never be privy to unless we're able to read through the tea leaves.
It could be, you bring up a good point there. It could be he's trying to bank some credit. You know me, I'm going to be in trouble. It's coming. Maybe this will help down the road if I help you now. I don't know. But if he thinks it's going to put him in the good graces with the cops, maybe that's the motivation. We shall see. Stay where you are, guys. We're coming back to this case out of Atlanta. Again, a little Woody poised to take the stand. We'll be right back.